Welcome back to Mimi Leaks, and thank you for your patience. As you may have noticed, I've been absent for a few weeks thanks to technical difficulties and travel and everything in between, and I appreciate you hanging in there during my unscheduled hiatus. Today, we're diving into a legal saga that has captured headlines: Jay-Z versus Jane Doe and her attorneys, and the whirlwind of allegations, dismissals, and counterclaims beyond the headline. If this type of content interests you, then please like the video and subscribe to the channel, and hit the notification button so that you're aware of new content as it's published. Let's start with the timeline. Back in October 2024, Jane Doe, represented by attorneys Tony Buzbee and David Fortney, filed a lawsuit alleging that in 2000, at an after-party following an event, she was victim to heinous crimes perpetrated by Sean Diddy Combs and Celebrity A, while a third person, Celebrity B, watched. By December, Jay-Z, whose real name is Shawn Carter, was named by Doe as Celebrity A and added to the lawsuit. Jay-Z swiftly responded, publicly denouncing the allegations and emphasizing his refusal to settle or pay what he referred to as a calculated blackmail attempt, and his attorney, Alex Spiro, accused Doe's legal team of pursuing the case with malicious intent. The back and forth between legal teams was intense. Jay-Z's team filed motions to dismiss the case, citing Doe's public admission of inaccuracies, and accused Buzbee of coercing Doe into the lawsuit in order to extort money. Buzbee responded, criticizing Jay-Z's legal team for alleged bullying and intimidation tactics. The public back and forth continued. However, in February 2025, Jane Doe voluntarily withdrew her case, and it was ultimately dismissed with prejudice, meaning that it cannot be refiled. But the story doesn't end there. On March 3, 2025, Jay-Z filed his own lawsuit against Jane Doe, Buzbee, and Fortney, accusing them of defamation, malicious prosecution, and abuse of the legal system and process. He alleges that the initial claims were not only false, but part of a calculated effort led by her legal team to extort him. So, buckle up as we read the counterclaim in this case. I will cover the entire complaint, summarizing the repetitive sections and reading in full the factual allegations as stated in the document. Please be mindful that the content of this video discusses sensitive topics, like that of assault. Therefore, your discretion is advised. With that, let's get started. The Southern District of Alabama, Mobile Division in the U.S. District Court. Shawn Carter, plaintiff, versus Anthony Buzbee, David Fortney, Buzbee Law Firm, and Jane Doe, defendants, filed by attorneys for plaintiff Shawn Carter. Introduction. A. False. B. Malicious. C. Strategically and tactically calculated and timed to inflict maximum pain and suffering on Mr. Carter, and D. In conspiracy with multiple attorneys, including defendants Anthony Buzbee and David Fortney, who, like her, were soullessly motivated by greed, in abject disregard of the truth and the most fundamental precepts of human decency. These are only truthful and fair descriptions of Jane Doe and her attorneys' malevolent efforts to assassinate the impeccable and lifetime earned character of Shawn Carter, who is professionally known as Jay-Z, but more importantly, is known as dad and husband and son, and a human being who did nothing to deserve or elicit the wanton, depraved attack that Jane Doe, in conspiracy with her attorneys, launched to extort Carter beginning on November 5, 2024, through a menacing private demand letter. Doe and her lawyers, Buzbee, Fortney, and Buzbee LP, also known as Buzbee Law Firm, are collectively the defendants, and brought before the world an in-court complaint, the impossibility and indeed absurdity of which was surpassed only by its vile malevolence, in a desperate attempt to leverage Carter into an extortionate payoff, with these malicious actors presented as the only path for him to prevent the public prosecution of a lawsuit by Doe. When their initial extortionate demand letter failed to yield a financial windfall, and after Doe told attorney Buzbee, a complete stranger prior to the demand letter, that she was not assaulted by Mr. Carter, Buzbee pushed her to continue with the story against him, then unnamed, for financial reasons. Buzbee then named Carter, knowing that her entire story as it related to him was completely fabricated. Jane Doe admitted to Carter's reps that the story against him was indeed false and driven by Buzbee's encouragement, intending to exploit the narrative for monetary gain. On the Friday before the filing of this suit, Buzbee and Fortney's co-counsel of the now dismissed suit threatened to double down on yet another false and public statement by Doe if Carter exposed the named defendants in Carter's pending California lawsuit against Buzbee. Carter resolutely exposed and countered Doe, Buzbee, and Fortney's malicious conspiracy, leading to the voluntary dismissal of their baseless complaint without settlement. Despite Jane Doe admitting to fabricating claims, her attorneys perpetuate extortion and threats. Carter, prioritizing ethics, protects her anonymity, but seeks justice. Carter sues Doe in defamation and malicious prosecution over false, damaging allegations. Parties. Plaintiff Shawn Carter, professionally known as Jay-Z, lives and resides in California. Defendants Anthony Buzbee and David Fortney are attorneys and residents of Texas. Buzbee is principal and Fortney is affiliated with Defendant Buzbee Law Firm. Defendant Buzbee Law Firm is organized under the laws of Texas and operates from Harris County, Texas. And for any non-Texas listeners, that encompasses the Houston Metro. Buzbee and Fortney's conduct was on behalf of themselves and Buzbee Law Firm. Defendant Jane Doe is a citizen of the state of Alabama residing in this district and sued in the SDNY under the Jane Doe pseudonym, later publishing her malicious lies as such on NBC News. Jurisdiction and venue. Because this matter exceeds the value of $75,000 and due to the parties residing in California, Texas, and Alabama, this court has jurisdiction. Venue is proper because Jane Doe resides in this district and because other defendants provided legal services, spoke, and met with her in this district. Allegations common to all claims for relief. 1. After hiring the Buzbee Law Firm, Doe falsely accuses Mr. Carter of assault in written correspondence, court filings, and on global television. Doe appears to be suffering from personal and financial hardship. She lost custody of her children and her parents, who support Doe, recently filed for bankruptcy protection. Desperate to obtain a payday, Doe hired Buzbee Law Firm, which has a long history of whipping up a media frenzy with vague and sensational claims against public figures to extort payments from Carter under the threat of devastating harm to his reputation. As discussed below, Doe first attempted to extort Mr. Carter through an extortionate demand letter and an anonymous letter, both from Buzbee. When Carter refused to capitulate to Doe's baseless demands, Doe doubled down by using the justice system to attempt to ruin Carter by formally naming him in a complaint, making horrific, false allegations. And when that also failed, Doe resorted to defaming Carter on global television. A simple Google or other public record search of Doe by Buzbee and Fortney would have cast doubt on her credibility by revealing that, among other things, A. Less than 90 days before sending the demand letter, she had been in court on mental health-related issues in connection with her second-degree assault charge and had her bail revoked for failing a substance test. B. She has several mental health disorders and takes multiple medications, according to testimony from her psychiatrist laid bare in public court records. And C. She made 3 other assault allegations, which were either dropped or dismissed by courts. A. Doe sues Shawn Combs' entities, and Doe's 1 through 10, alleging she was assaulted at an after-party following the 2000 MTV Video Music Awards. On October 20th, 2024, Doe sued Sean Diddy Combs and his business entities, as well as Doe's 1 through 10. Although Doe's lawsuit implicates unnamed Celebrity A and Celebrity B, Doe does not formally name them as parties. Instead, Doe only sued Doe's 1 through 10 as defendants. In her original complaint, Doe alleges when she was 13 years old, a friend dropped her off at Radio City Music Hall in New York City so she could try to attend the VMAs on September 7, 2000. Although she was unable to talk her way into the VMAs, a limo driver purporting to work for Combs invited her to an after-party. Later that evening, the limo driver took her to a large white house with a gated U-shaped driveway about 20 minutes away. After accepting a drink, Doe claims that she felt woozy and lightheaded and found what she believed to be an empty room. She alleges that Combs and Celebrity A assaulted her while Celebrity B watched. It has become evident that Doe did not initiate this legal action with a legitimate purpose. Instead, the lawsuit was filed with the intent to extort Carter. B. Doe sends Carter an extortionate letter, falsely accusing him of assault. A few weeks after filing her complaint, Doe, through Buzbee, sent Carter an extortionate letter dated November 5, 2024, containing false allegations of vile conduct by Carter. Some of the allegations in Doe's letter were from the public complaint that she filed against Combs and Doe's 1 through 10, which contained inconsistencies that were later changed when the complaint was amended, with obvious implication being that she would amend her complaint to add Carter if he refused to pay. Doe threatened to take a different course if Carter did not commit to a confidential mediation or resolve this delicate and important matter by the deadline of November 19th, giving Carter only a 2-week window before she would go public with her false allegations. To avoid both public and criminal exposure, Buzbee stated that his client wants something of substance by way of settlement. However, Doe had already sued Carter, albeit as Doe's 1 through 10. And so Doe's plan was clear. She was demanding that Carter either A, pay something of substance to stop her from making public the wildly false allegations of assault that would subject Carter to opprobrium and irreparably harm his reputation, family, and livelihood and career, or 2, endure that financial and personal ruin. Doe's statements and correspondence made clear the immediate and extensive threat of exposure if Carter failed to pay. C. Doe amends her lawsuit to falsely allege that Carter assaulted her. Unwilling to capitulate to Doe and Buzbee's extortion, on November 18th, Carter filed a lawsuit against Buzbee for extortion and intentional infliction of emotional distress. Carter explained that Buzbee was shamelessly attempting to extort exorbitant sums from him, or else publicly file wildly horrific allegations against him. On December 8th, humiliated by Carter's lawsuit, Buzbee encouraged Doe to file, and Buzbee and Fortney filed a first amended complaint, revealing what Carter knew all along, that one of the Does was a placeholder for Carter if he did not pay her ransom. In Doe's first amended complaint, Doe makes wild, horrific, but utterly false allegations against Carter, substituting him for Celebrity A from the earlier complaint. D. Doe goes on global television, falsely accusing Carter of assault. On December 13, 2024, NBC News broadcast portions of an exclusive interview of Doe, which was conducted with Fortney by her side. NBC News honored Doe's request to mask her identity. NBC News published a story excerpting interviews that it held with Doe. And during the interview, which was held up by Buzbee, she was given a voluntary basis and, in the presence of Fortney, Doe lied about Carter to a global television audience. In addition to attempting to explain the impossible, how she, as a 13-year-old from upstate New York, wound up in Manhattan at a private VMA party with countless celebrities, Doe told NBC News how she spoke with musicians Benji Madden and his brother at the after-party. She recalled talking to Madden about his tattoo of the Last Supper because she has a religious background, so it would be something to talk about. Doe repeated her claims that while at the after-party, she had a drink that made her feel woozy, after which Combs and Carter took turns assaulting her, while an unidentified female celebrity watched. Doe told NBC that following the alleged assault, she found her way to a gas station where she called her father, who picked her up and drove her home. She states her father did not ask what happened, what she did, or where she was, and instead they roamed home in silence for 5 hours and 47 minutes. 2. All of Doe's allegations against Mr. Carter were demonstrably false. Doe's allegations about Carter are false and defamatory, and her mendacity is clear, including to the reporters at NBC News. First, although Doe stated the assault occurred at a residence, Carter was at no such residence. Indeed, NBC News located photos of him from that evening showing him at a party at a commercial location, the now closed Lotus nightclub of NYC. Of course, a private nightclub cannot be mistaken for a large white residence with a U-shaped gated driveway that included a large living room or foyer, or a hallway containing several rooms off of it, and a bedroom. Even Buzbee admitted to NBC that Doe does not claim the assault occurred at Lotus nightclub. Second, Doe told NBC that she spent 20 minutes in the limo before arriving at the residence. However, when pressed about these details in a follow-up interview with NBC, Doe admitted she did not know where she was going or even how long the drive took. Worse, she conceded to NBC that she guessed about the length of time the trip had taken in the lawsuit. Third, as her deception of a supposed conversation with Benji Madden during her interview with NBC was described, a representative for Madden confirmed to NBC News that neither he nor his brother Joel attended the 2000 VMAs, that they and their band Good Charlotte were on tour in the Midwest at that time. When confronted with this evidence, she conceded that she made a mistake in identifying them and that not all the faces at the after-party were clear. Fourth, regarding her long pre-dawn drive home with her father, Doe's father told NBC News that he does not recall picking up Doe, which, unsurprisingly, would have been something that definitely would stick in my mind. He said that he learned of the alleged assault when Doe was interviewed by NBC News in December, and that he did remember once picking Doe up in the middle of the night, but it was a local drive. Based on their address in Rochester, New York, Doe's father would have driven at least 5 hours and 47 minutes to pick her up. And there are other countless falsehoods in Doe's allegations. For instance, despite alleging it took 20 minutes to get from Radio City Music Hall to the after-party, there are no houses matching Doe's description within 20 minutes of Radio City Music Hall. And although she implies that Combs hosted the after-party, none of Combs' properties match Doe's description of the location of the after-party. Moreover, Doe alleges that after the VMAs began, much of the crowd moved inside, but Doe, without a ticket, remained outside with others and watched the VMAs on a jumbotron. But the broadcast of the VMAs conclusively shows that there was no jumbotron. Indeed, the producer of the 2000 VMAs and the NYPD confirmed that there was no jumbotron since their permit application was denied. Even if Doe was outside the VMAs as she claims, she could not have approached celebrity limousines because they were only outside of Radio City Music Hall briefly for celebrity pickup and drop-off. In any event, the celebrity limousines were separated from fans by police barricades, as publicly available video of the event clearly shows. NBC confronted Doe regarding this substantial contradictory evidence, which it had uncovered in less than a week after conducting the initial interview, in a follow-up phone interview. In response, Doe admitted that she had, quote, made some mistakes. She also disavowed the allegations in her complaint about the location of the alleged incident and admitted that she was just guessing. But Doe did not drop her baseless complaint, instead insisting on moving forward, including by offering to submit a polygraph, which she never did, or, in any event, has never seen the light of day. 3. Doe waited months before dismissing her false complaint and did so after being lied to by her attorneys for their own benefit. Carter made several court filings repeatedly by detailing the falsity of Doe's claims, as revealed by her story's inconsistencies and the baselessness of various allegations. At each of these junctures, Doe was confronted with the false nature of her claim, as well as the harm it was causing Carter. At any of these points, she could have withdrawn her lawsuit. Nevertheless, Doe continued to pursue her claim without regard to the harm it would be causing or could cause Carter. Now, she has admitted that Carter did not assault her. Indeed, Buzbee, aware that Carter did not assault her, pushed her to make the false claim for money. Having already sent the false and defamatory demand letters, having filed the false and defamatory complaint, and having already set Doe up to give the false and defamatory interview to NBC News, Buzbee, Fortney, and the Buzbee law firm were happy to perpetuate the lies and hold out hope for an unwarranted payment for them and Doe. Indeed, Buzbee went so far as to tell TMZ on December 10, 2024, already fully aware of the falsity of the allegations, having met with Doe in Houston, that Doe was not ruling out filing R charges against Carter, and what happens next is up to my client. It's her case, and what she decides to do, you will find out in due course. However, the legal process got in the way of their scheme. Buzbee had signed the complaints in the action against Carter without being admitted to the bar of the U.S. District Court for the SDNY as required. When the judge was advised of this fact, she issued an order dated January 28, 2025, requiring Buzbee to file proof of admission to the SDNY on the docket by February 14th. The very next day, January 29th, Buzbee applied for such admission. On February 13th, one day before his deadline to file proof of admission in the SDNY, Buzbee got the news that because he was already filing pleadings in the SDNY without being admitted to the bar of that court, in the case at issue here and in more than 20 others, his application for admission had been denied. He was also instructed to attach a copy of the denial order to any subsequent application in the SDNY. Faced with his inability to comply with the judge's order in the case against Carter and facing the threat of punishment by the court, Buzbee dispatched Fortney to Alabama to meet with Doe that same day, namely February 13th. During the meeting, Fortney falsely, maliciously, and manipulatively told Doe that the case against Carter needed to be dismissed, as Carter made threats against Doe's life and it was too dangerous to continue with the case. Of course, no such threats have ever been made. Rather, Buzbee and Fortney were desperate to withdraw the false case or face punishment in court for their actions in filing a false pleading without Buzbee even being admitted in the SDNY, jeopardizing their ability to continue with more than 20 other cases they have pending in the SDNY. Thus, on the evening of Friday, February 14th, Doe quietly filed her voluntary dismissal with prejudice. But the threats and extortion did not end with the dismissal of Doe's fraudulent lawsuit. Rather, on Friday, February 28th, after Doe admitted all the foregoing and after Buzbee became aware of those admissions, a prominent New York attorney, serving as Buzbee and Fortney's co-counsel, called an attorney for Carter, and during that call, Buzbee and Fortney's New York co-counsel threatened that if Carter's attorney filed anything in Carter's pending extortion and defamation case in California against Buzbee related to the statements made by Doe, fully exculpating Carter and inculpating her and Buzbee for extortion and conspiracy, that Buzbee would issue a false statement by Doe that she, one, was being harassed by Carter's people since she dropped the lawsuit, and two, dropped the lawsuit only because she was afraid for her life, and that the allegations against Carter in the dropped lawsuit were all true. Of course, Doe's allegations about being harassed by Carter's people, since she dropped the lawsuit, about her reasons for dropping the lawsuit, are and always were false. When Doe, Buzbee, and Fortney and her New York co-counsel said they knew or could readily have discovered through any reasonable inquiry that these statements were false. Thus, the threats of extortion and further defamation continue to this day, necessitating that Carter take action to prevent unscrupulous actors from further preying on him. Now we get to the causes of action, and the first and second are against all named defendants, the first being malicious prosecution, and the second being abuse of process. and both causes state the following. On October 20th, 2024, Doe and her attorneys filed a baseless lawsuit to extort Carter. On November 5th, Doe, through Buzbee, sent a threatening letter to Carter with fabricated allegations, claiming that he assaulted her at a 2000 VMAs after-party to extort him financially. After Carter's refusal, through Buzbee and Fortney, Doe amended her lawsuit to name Carter directly, despite knowing the claims were false, which aimed to irreparably harm his reputation, family, and career. Doe exploited NBC News and other media platforms to spread false assault allegations against Carter, but NBC quickly disproved her baseless claims with contradictory evidence like the following. Doe claimed the assault occurred at the VMA after-party at a gated white residence, but evidence shows Carter attended an event at Lotus nightclub in New York. B. She alleged her father picked her up, a 13-year-old, after the assault, driving 10 hours round trip, when he has no recollection of doing so. C. The sole celebrity that Doe named, of the multiple she claims to have conversed with at the alleged after-party, was performing out of state in the night in question. D. Doe's claim of watching the VMAs outside on a jumbotron is refuted by officials and contradicts photographs of the evening. And E. The limo area at the VMAs was inaccessible to fans, contradicting Doe's account in which limo drivers were accessible. Doe admitted her allegations were inaccurate and were guesses. Even after NBC exposed her inconsistencies, defendants still maliciously pursued the baseless lawsuit, spreading false allegations through media. This caused Carter significant financial, reputational, and emotional harm, as well as harm to his business Roc Nation, including over $20 million in losses, before being dismissed with prejudice in his favor. Carter is entitled to punitive damages due to the willful, malicious harm intended to oppress and injure him. Skipping through the second cause, which is exactly the same as that. Third cause. Civil conspiracy against all defendants. The defendants agreed, worked together, and conspired to maliciously prosecute and abuse the legal process against Carter, with the shared objective of extorting him through false, damaging accusations that would cause him harm. They took overt actions to achieve this malicious prosecution and to abuse the courts as follows. Buzbee, as Doe's attorney, filed the initial lawsuit, knowing the allegations against Carter were false and reckless. Fortney, representing Doe, was complicit through pursuing the suit, and both attorneys continued to prosecute even after confronted with further disqualifying evidence. Doe participated in formulating and prosecuting these claims as well. The conduct was intentional and executed to extort Carter and damage his reputation. As a result, he suffered harm, out-of-pocket expenses, and emotional distress. Fourth, defamation against Doe. Doe made false, defamatory, widely spread statements through interviews and to and through third parties, media outlets, and platforms. Doe relied on media sources to republish and distribute the statements to millions in the general public, doing so on December 13, 2024. Doe's accusations were stated as a statement of fact and truth. At a minimum, she acted with reckless disregard, demonstrated by NBC's ability to quickly contradict her statements. She admitted her accusations contained mistakes and guesswork by knowingly, intentionally publishing these false allegations. Doe acted with malice. Using media to disseminate to millions was part of Doe's calculated plan of inflicting reputational harm to induce payment. Her false and defamatory statements are defamation per se, a type of statement that is defaming on its face, and the statements on their own subjected Carter to disgrace, ridicule, public hatred, and contempt. Carter was directly injured, and his reputation, professional relationships, and business opportunities are at risk of damage. Doe's statements also constitute defamation per quad, that is, where the court must look at the context of a given statement. As it was reasonably understood, she spoke of Carter. She implicated him in allegations involving intimate misconduct across media platforms and her statements were injurious to Carter's ability to secure business opportunities and in preserving his reputation due to the public ridicule, hatred, and contempt that he was exposed to. Carter suffered damages not limited to harm, loss, or injury to his business, name, and reputation, out-of-pocket expenses, emotional harm, and humiliation. Doe's actions were a substantial factor in this harm, and it was done with constitutional malice. Even after given ground to withdraw her statements, Doe continued to threaten criminal prosecution and civil damage against Carter through her attorney. This lacked reason and acting in reckless disregard for the truth, even asking one of Carter's reps, quote, "What's in it for me?" unquote. Prayer for relief. Shawn Carter prays for judgment and relief against the named defendants in assumed and actual damages, as determined by the finder of fact, as well as punitive damages, reasonable costs and legal fees, pre- and post-judgment interest, and any other relief deemed just and appropriate. Carter demands a jury trial, and this is signed by his attorneys, the attorneys for Plaintiff Carter, on March 3rd, 2025. Thank you for watching this breakdown of Jay-Z's countersuit against Doe and her attorneys. High-profile cases like this, especially if successful, may encourage others to pursue similar lawsuits. Indeed, celebrity countersuits have drawn significant attention over the past couple of years, shedding light on the ethical duties of attorneys and the importance of safeguarding against the misuse of the legal system. If you found this video insightful, don't forget to give it a thumbs up and hit that subscribe button for more breakdowns, analysis, and behind-the-scenes stories. Stay tuned, and I'll catch you on the next one.